The State Consumer Protection Act study is the culmination of a massive data collection effort to provide some empirical basis for policy discussions involving issues of state and federal consumer protection litigation. Our first key finding is that the total number of Consumer Protection Act decisions under state Consumer Protection Acts increased 119% from 2000 to 2007. This represents a major increase in litigation activity under these state acts and is an important part of the policy debate. That 119% increase in total decisions across both federal and state courts is a dramatic increase relative to other types of causes of action, so for example, general tort litigation over the same time period, and signals that state consumer protection activity is an important policy issue demanding the attention of policymakers. A second key finding of our study is one of the characteristics of state CPAs that's a strong predictor of the amount of litigation in that state under state consumer protection acts is how the statute's actually drafted. There is a lot of variance in drafting of the statutes, in particular how we define illegal conduct under the statute, ranging from states which have incredibly vague open-ended definitions allowing judges full and complete discretion to identify conduct that violates the statute to those with explicit laundry lists of violations. What we find in the study is that states with vague statutory definitions of illegal conduct under the state CPA have a 30 to 50%, depending on the empirical specification, a 30 to 50% increase in state CPA litigation activity relative to states with laundry list approaches to identifying violations. One of the most clear trends in changes in actual state consumer protection legislation is that amendments to those statutes have generally gone in the direction of making suits more generous to plaintiffs. What we mean by that is that amendments to these statutes have either increased remedies available to plaintiffs given a finding of a violation, or lowered the burden required of plaintiffs to establish a violation, or reduced standing requirements. What we find with states with more generous provisions for plaintiffs in their state consumer protection acts is that these states predictably experience a higher level of litigation activity than those that don't. While analysis of these 17,000 decisions and the relationship between changes in state CPAs and litigation activity is helpful in identifying trends and important sources of interstate variation, another key question is whether we can identify differences between claims brought under state CPAs and those under the federal counterpart. The first approach we took to addressing this question of whether the state CPA cases were qualitatively different than their federal counterparts, we took a random sample of actual litigated state CPA decisions and asked the Searle Shadow Commission, a group of 5 consumer protection experts we put together with significant experience in application of the Federal Trade Commission Consumer Protection Act standards and with Federal Trade Commission Consumer Protection Enforcement to analyze those cases. The Searle Shadow Commission found that in 78% of this random sample of actually litigated state CPA cases, the conduct at issue in those claims does not violate the Federal Trade Commission Act standard. In other words, in 78% of the cases actually litigated under state CPAs, the Commission was not able to find any conduct that would violate the FTC Act.